Thank you, Dr. Lipson. Our next speaker is Gang Luo, a PhD candidate in law at the University of Paris 1, Panthéon-Sorbonne. I invite Gang Luo to give his lecture regarding legal conservatism in the process of legal transformation in East Asia under the influence of Western laws, a comparative observation of modernization of family law in China and Japan.
Thank you. Good morning, everyone. Oh, perhaps there is a display problem. No problem. My name is Gang Luo, and today my topic is about the legal history of the family law in East Asia, the legal conservatism in the process of legal transformation in East Asia, and the influence of Western law, a comparative observation on modernization of family law in China and Japan. Okay, today's my topic cover 5 points. The first, besides the introduction and concluding remarks, I will cover the concept I will be used in this presentation, the legal conservatism, and the two value elements, liberty and equity, in the family law transition. Okay, the first. Perhaps as you know, China have the vast territorial and long history and a huge population. I will start with the dynasty of the Tang. In the Chinese history, the Tang dynasty is considered as a high point of the civilization. In that time, it's very open, and a lot of foreigners lived there, and the capital of the Chang'an is very popular there at that time. And during its prosperity at Tang Dynasty, our neighborhood Japan sent a lot of students and officials to land it on China to try to learn everything from China from the 8th century and 7th century to 9th century, and including the Chinese Confucian philosophies, government structure, writing system, literature, religion. And in the Chinese legal history, and we will find before the modern time, China law is based on the two pillars. The first is we call the Li, that is the morality is education morality, and which based on the Confucianism. The other is a law, and the Western scholar call the law is primarily the code law. And from the 19th century, China began to be influenced by the Western culture, Western law, primarily the European continental law. And from the 1949, China began to be influenced by the Soviet Union law. And until recently, China began to be influenced by the European continental law, and now is drafting a new civil code. Next to the Japanese legal history, in the 7th and 8th centuries, Japanese law is much influenced by the Chinese political and political and legal system based on Confucianism. But from the 19th century, Japan began to carry out the legal and political reform earlier than China, and as a defeated nation in Second World War II, Japanese law after 1945 is much influenced by the U.S. law, especially in the Constitution. But however, it's a strong influence of the civil law system remains in today's Japan. Okay, let me make some comparison. And before the mid-19th century, and both China and Japan share the two elements. The first is Confucianism. The second is it concerns foreign policy, isolationism. Confucianism very important in China and Japan legal history because their traditional family law was based on it. And due to some piracy from the 15th century in Chinese history and in Japan, Chinese and Japan began to carry out the foreign policy of isolation. That's why later the Western powers asked China and Japan to open up their market. Okay, from the mid-19th century, China and Japan was faced the same situation. The Western power arrived, and they both signed the unequal treaty. And however, facing the same situation, China and Japan make different approaches of the social reform. China began to carry out the social reform only limited on the economic reform. However, Japan began to carry out a comprehensive reform, including the political and the legal reform. The original motivation of the reform for China is not weaker than the West, and Japan is stronger than the West in order to have the unequal treaty revised. And then here comes a military disaster for China. In the late 1890s, there's a war, for Sino-Japanese War, and China was defeated. At that time, the thought-provoking question was posed by the Chinese scholars, because previously China is a big country, a huge country and a strong country, and Japan is a small country, island country. So the people at that time think about why we are defeated. It was China's military defeated in the war is associated with the absent political legal reform. This is a question. So in the early 20th century, China began to carry out a legal reform towards the modernization. Okay, next let's move on the concept of legal conservative, and I will cover two perspectives. The first perspective is about the historical evolution perspective. There is a very interesting question as opposed to the historical evolution of in the Western legal tradition. In China, for almost 2,000 years, the legal ideology, that is the Confucianism, never changed from the Han Dynasty 2 centuries before Christ to the late Qing Dynasty in the 19th century. And although there's a lot of replacement of dynasties, however, in the West, the ideology, the rules, the ideology behind the legal rules are changing. For example, in the divorce law, in the Roman times, divorce are admitted. However, according to the Christian tradition, the divorce is not permitted. And in the French Code Civil times, there's a compromise between the traditional law and the modern law. So I think the legal ideology behind the West, in the West, is changing, but in China, it's not changing. So that is a very interesting question. So in this sense, I think the concept of the legal conservatism. The next perspective is about the nature of the family law itself. And I think all the legal areas can be divided into perspective, two aspects. The first is a culturally discriminated nature. The second is a technically neutral nature. For the second, I think is a typical example is a contract law. And if you look at the current comparative law book, and you will find the comparative law more often give the example of the contract law, but the family law is controversy because it has the cultural basis varies, and its cultural basis vary from region to region, from time to time. Even in the first comparative law congress in Paris in 1900, some scholars even question the very existence of comparative public law, comparative family law. Okay, based on these two perspectives, I will give you example of the code, civil code drafting in China and Japan. And in Japan, Japan would like to introduce the Western code, especially primarily first the French civil code by direct translation. However, the translator ran into some problem because they found some of the words in Western language cannot find the corresponding words in Japanese language. For example, the rights. And so the Japanese legal translator event such was Ken Lee, and the Chinese borrowed this translation and it was used until today. Then next, Japanese government find that is not impossible, so they invite a French legal scholar named Gustave Boissonade to drafting a new Japanese civil code. However, this version of the civil code is drafted, mostly part of this drafted by this French legal scholar, except for the family law and the law of inheritance, because this part of the family law and the law of inheritance is prepared by the local Japanese legal experts, because this civil code at that time caused a lot of controversy in Japanese society, because some scholars feared adoption of such European family concept will lead to the breakdown of the strict hierarchy of the Japanese society based on the Chinese Confucianism. Because the concept of the European family is based on the equality of the husband and the wife. And in the traditional Confucian society, that is not. Okay, and after such a controversy, and in the 1890s, the Japanese government organized another commission and another draft, and this draft is totally based on the German style. And the Japanese at time Japan very worried about the progress of the civil code. There is an opening speech of Prime Minister at the Diet. If Japan misses this opportunity to prove itself to be a modern state, the Japanese would have waited 30, even 50 years to have the equal treaties revised. So finally, the Meiji Civil Code of Japan, adopted 1898, was based on the German style. Next, in the early 20th century, China began to carry out legal reform for the civil code, is modeled after the Japanese civil code. So some scholars even said this version of civil code, Chinese civil code, is sometimes is a Chinese version of the Japanese civil code. Just as the same, the first three parts, the structure of the civil code is based on the German style, and the first three books, the general principles, obligation, property law, Sachenrecht, is drafted by Japanese legal scholars based on the German structure, and the last two books, the family law and the law of the inheritance, drafted by the four Chinese drafters. They all graduated from the overseas university, and two of them graduated from Japanese law school. Okay. Next, I will rapidly to give you some the liberty and the liberty and the equity value in the family law. I mean, let's simply comparison. The first is about the Confucian legal system and about the arranged family. In the traditional Chinese time, China time, the parental power is very strong, and if you would like to make a marriage, and the parental consent is required. But in contrast to the Christian time, this is only socially acceptable practice, but not a requirement, a social norm. And according to the Christian legal tradition, the marriage cannot be divorced. And however, in China and Japan, the Confucian legal system, and this can be achieved by some the grounds. And the mogonami is a requirement of Christian doctrine, but mogonami is not a requirement of a Christian doctrine. It's only the in Confucian in Confucian tradition is only for the purpose of the inheritance in the extended family, and is socially accepted, practiced frequently in the upper class. And then next, and the abolition of the arranged marriage and the monogamy is in the period of modernization in East Asia is abolished gradually. It's not at a sudden. And here is some example of China and Japan's legislation. About the equity, traditional legal tradition, Confucian legal tradition in the pre-modern Eastern Asia is based on the Confucian family law. That is three features. The first is a male-dominated extended family and a hierarchical family. This family tradition is against the individualism value system, and there's a lot of inequality in legal status among the family members, especially between the husband and the wife, and the legitimate child and the illegitimate child. And the period in the period of the modernization of East Asia, and to realize the equal between family members is gradually, is not suddenly. For example, at the very beginning of the early 20s, the Civil Code of Great Qing and the Meiji Civil Code, there's still the inequality between husband and wife, and later they be changed. Okay, as my concluding remarks, and the first is Confucian family law is private law, public law. I think the private public law and private law divide is a Western approach, is a Roman time. The question is about is a Western approach or the universal approach? Because in the Confucian legal system, the legal areas not divided legal areas, totally based on the philosophy principles of unity of the heaven and the person. If we apply such approach to the Confucian family system, I think it's more close to public law, because the family is a governmental policy based on the emperor-centered political system. To some extent, amending the Confucian family law is just like the drafting new constitution. If you have learned the Chinese or Japanese language, the word state is based on two parts. The first is the state, the second is the family. The state is a reduced, enlarged family, and the family is a reduced state. So another interesting question is about the Japanese traditional ES system, the family system. It has an extreme effect, that is emperor worship. So is this responsible for its war crime in the first half of 20th century? And this is a very interesting question. A Japanese scholar said the slogan of constructing the Great Asia may not be easily comprehensible, but when it is planned as making Great Asia one family, all becomes clear to the Japanese. So the last is the Confucian family law in transition. I think to some extent is preservation of a Confucian public law. When the Western law influence arrived, that means the liberal and the equal elements arrive, and the Confucian family law is compatible with the traditional agricultural society. That at that time there is a lot of extended family and a new human migration, and not incompatible with the modern industry society. If to realize the Confucian family in transition, to realize the modernization of the family law in East Asia, that means they put private autonomy in the family matters. Okay, thank you for your kind attention.